Vince.
Counsel, ladies and gentlemen of the jury, it's almost like the prosecutor was watching a different trial than the rest of us. Because the state's case, after all of this evidence has been presented, boils down to a bunch of could-haves, hypothetical scenarios, and excuses. Excuses for why they didn't do the criminal investigation that should have been done in this case. The type of criminal investigation that the state has an obligation to do. Because the state, the law enforcement agencies, and we've got two of them in this case. We've got the Sandoval County Sheriff's Office, and we have the New Mexico State Police. Two agencies that could have and should have done a thorough, unbiased investigation. And instead, what we have is this half-hearted, sloppy, I'm sorry to say it, sloppy, incomplete investigation. And now the state's asking you to prosecute and convict Mr. Cummings of murder? Let's talk about what the evidence actually showed in this case, the evidence that you saw during this trial. The state started its case with Officer Walker. Officer Walker, who seems like a nice enough guy, but he had spent his entire law enforcement career skipping from one agency to another, to another, to another, until now he's not even in law enforcement anymore. Officer Walker sounds like the first person who had contact with Mr. Cummings that day. When the police finally arrived on scene, took him a while to get there. Mr. Cummings waiting patiently for them to arrive. And Officer Walker testified on direct examination that Mr. Cummings refused to provide his name, and that he had asked Mr. Cummings his name and he wouldn't tell him. As you may recall, my co-counsel asked him to listen to his entire belt tape. We took a break for the night, at which time he did. And then he had to come back into court and he had to tell you, he had to admit that his statements were not true. He actually never did ask Mr. Cummings his name. So that's our first state's witness. He also denied that Mr. Cummings ever said, "I'm devastated." Denied that he ever said that. And my co-counsel again had to play his recording back to him so he could listen to it, and you could all listen to it again, when it is as clear as day that one of the first things that Mr. Cummings said to those law enforcement officers is, "I'm devastated." And yet the state wants to spin it like he was having no emotions at all that day. The state ignores the fact that during the 911 call made by Mr. McCullough actually says that Mr. Cummings seems pretty shook up. It's in the 911 calls. You have them. If you want to listen to them during deliberations, you may do so. So even Mr. McCullough says he seemed shook up, and then he describes himself as devastated. But I'll give Officer Walker credit. At least he was running his belt tape. At least he was running that recording device. Because in this case, I think it's become really clear why it's so important that law enforcement have recording devices whenever they interact with the public. It's so important because just with Officer Walker, we saw all these numerous inconsistencies and inaccuracies in his testimony that he had to be confronted with using his belt tape. And so at least he was running it. Another law enforcement officer ran a recording device out at the scene. Officer Crespin says he was running his lapel camera. He says that he was running it and he made multiple videos throughout his investigation that day. And yet somehow, oddly, oddly enough, that is the one case where his videos disappeared. He told you about how he would download all of his videos once a week. And he admitted that all of the videos from that week, that included February 29th, all of the other videos from all of his other calls that week were downloaded. Crazy. All of the videos just for Mr. Cummings' case disappear. No explanation for that, and I don't have an explanation for that. Either he was not telling the truth when he said he was running his camera, or they were destroyed or lost. Officer Crespin is also the officer who doesn't even know what time the sun sets. He couldn't even tell us accurately when the sun had set the day before. And so the state wants you to take his testimony and believe that he actually was interrogating Mr. Cummings and asked him for 3 hours what his name was, and that he didn't know his identity, despite the fact that Mr. Cummings had actually called 911, had given his name, had given his phone number, and told the 911 operator, I have been attacked. Attacked. Where's the 911 call Mr. Cummings made? Why do we have 4 911 calls from Mr. McCullough, and we don't have his? We don't have Mr. Cummings.
Objection, Your Honor. Please approach.
As I was saying, the state never even obtained Mr. Cummings' 911 call. Why not? They can clearly get 911 calls because they got Mr. McCullough's. Why not get his? Then, moving on to Sergeant Griffin. Sergeant Griffin was the investigator at the scene responsible over the investigation of the ranch. Sergeant Griffin came in here, ladies and gentlemen, and told you this was the magazine recovered from the scene, and these were the casings recovered from the scene. Their lead investigator on scene tells you this. It's not a big mystery that this is not the right magazine. This is the right magazine. Why do we have 2 magazines? The state doesn't even know what their evidence is, and we don't know where this stuff comes from.
Your Honor, I'm going to approach. I'm sorry, but this is really unfair and prejudicial.
Sergeant Griffin also testified that Mr. Cummings told him where his clothes were located, told him he had been attacked and sprayed with some kind of a chemical, and asked him to tag those pieces of clothing into evidence and to test them. To test them. None of that was done. The testing, obviously. Then we hear from Officer Herrera with the New Mexico State Police, our second law enforcement agency on scene. Officer Herrera described how when he went out to the scene, he did some preliminary investigations. We see the photos that were taken. We see the evidence markers. And we see some trajectory rods. What we don't see, though, is a complete shooting reconstruction. The state never did that. They have people, they have a whole Department of Public Safety that could have done a shooting reconstruction. Why didn't they do it? Instead, it was left to the defense. We had to hire a shooting reconstruction expert, Aaron Brudenell, and ask him to try to piece together the scene based upon what had been collected by the state police and by the Sandoval County Sheriff's Office. But a lot more could have been done at the scene, and it wasn't. And ladies and gentlemen, I would submit to you that the reason the state didn't do a complete shooting reconstruction is because it wouldn't have helped their case. Because once we saw the complete shooting reconstruction, we see that it actually proves Mr. Cummings is telling the truth. I apologize, I should have gotten this set up before I started. So what we see once we finally do a shooting reconstruction is a scene that is chaotic. A scene with impact sites showing that this gun was on the ground upside down when at least 2 shots were fired. Who intentionally kills somebody by laying on the ground, turning their gun upside down, and shooting? The state seems to be trying to suggest that Mr. Cummings could have done that after he shot Mr. Arriola. Again, could have, without an answer is reasonable doubt. It's also ridiculous, quite frankly. And you heard Mr. Brudenell explain why that scenario was incredibly unlikely. He would have had to have pretty much laid across the body in order to achieve that. And as the state pointed out in their own closing, there was no blood on his clothes. So how is he laying across Mr. Arriola's body when he's lying there bleeding out, shooting this gun off at this incredibly odd angle and location, and not getting any blood on him? Again, this is just sheer speculation by the state. Moving on, our case agent, Lieutenant Tomlinson. Lieutenant Tomlinson oversaw this entire investigation from his office. He never went to the scene. He never bothered to order the testing of Mr. Cummings' clothes. He never bothered to have the gun tested for traces of mace. He never even bothered to speak with Carlos Herrera. Instead, he went before the grand jury and he testified to a series of statements that were not true. He then comes in here and testifies before you all and explains that he was in a coma last year and therefore he can't remember his grand jury testimony. But he can remember the details of his investigation just a few weeks earlier. And whether he can remember the grand jury testimony, whether he can remember the investigation or not, doesn't really matter. Because the fact that he may have been in a coma a year ago doesn't explain his lack of investigation 2.5 years ago. It doesn't explain his grand jury testimony 2.5 years ago. We also heard from Dr. Jarrell at the Office of the Medical Investigator. Dr. Jarrell is a professional. She is a forensic pathologist. She comes in here and testifies as to the facts as she sees them. What she did not do was testify that Mr. Arriola was on his knees. She did not testify that the shooter was over Mr. Arriola. In fact, she said she doesn't know where the gun was. She's not going to speak to where the shooter was. All she could testify to is the trajectory of the wounds and basically the toxicology results. She told you. She also never testified that Mr. Arriola would have dropped that can of mace when he was shot. There was never any testimony about that. That is all the state, spinning the facts to suit their needs. What Dr. Jarrell did testify about that is important, I think it's very clear why it's so important now, is the fact that Mr. Arriola was intoxicated. He was a .118. For context, the legal limit for driving while drinking is a .08. So Mr. Arriola was over the legal limit for alcohol at the time of his death, and he was using cocaine, and that the cocaine and alcohol were used close enough in time that it actually combined to create a different substance called coca-ethylene. Coca-ethylene in the body can increase aggression and risk-taking. She testified to all of that. And then we heard from the state's DNA analyst, Ms. Otto. Ms. Otto testified that Dean's DNA was found on the gun. Of course it was found on the gun. That makes sense. It's his gun. He never denies handling it. She also testified that when they tested the gun, when they're swabbing it, looking for DNA, they didn't swab the scope at all. They didn't swab the muzzle at all. All of their swabbing was focused down here, which is consistent with what Mr. Cummings was saying, where he was holding the gun and where Mr. Arriola was grabbing for the gun. Mr. Arriola was grabbing for the gun here and here, ripping the cap off the scope. So no wonder they never found Mr. Arriola's DNA on his firearm. They didn't test the right places. Mr. Cummings' DNA is never found on the mace canister. And by contrast, this is small. This is compact. Ms. Otto testified that when they would swab something like this, they would have swabbed the whole can. They were able to get all around it because it's small compared to this. And Mr. Cummings' DNA isn't on here. Mr. Arriola's is, of course, because as we now know, Mr. Arriola loved his can of mace. We also heard from Mr. McCullough and Christine Landers. Mr. McCullough came in and he told you what happened that day to the best of his memory, testified that Mr. Cummings was pretty shook up. We have no dispute with what he testified to. Ms. Landers, you heard her testimony. You will ultimately be the judges of credibility. Ms. Landers, it appeared that she was looking for a quick buck. She wanted this real estate contract signed quickly. She didn't want to bother with other agents or allowing Mr. Cummings the opportunity to speak with a lawyer. She wanted him to sign that contract that day right away. She was even annoyed that he read the contract. She didn't even want him to read her contract, and she certainly wouldn't give him a copy of it. She also claimed she knew Mr. Arriola for over 20 years. Apparently, she didn't know the same Mr. Arriola that everyone else did. Because let's talk about some of the people who really knew Guillermo Arriola. Debbie Dominguez and Joe Chavez. And remember, these are people that don't know Mr. Cummings, never met him before. They came in here yesterday and they talked to you about the real Guillermo Arriola. How they were both maced. Multiple members of their family were maced. No dye in that mace. He even maced their dog. And then you hear from Mr. Klinger. Mr. Klinger, who doesn't really know anybody. Doesn't know anybody. He was just there to buy some medical equipment. Mr. Klinger's only connection is the fact that he had done a couple of transactions with Joe Chavez for sounds like some kind of medical devices or some insulin because they both were diabetic. And he testified that he had just pulled up to the gate and was waiting to be let in when all of a sudden Mr. Arriola comes up and starts attacking his car with a hammer. A hammer. Never met the guy before in his life, and Mr. Arriola breaks out his tail light and is banging the hammer all the way down the side of his car. He gets out to say, "What are you doing?" And Mr. Arriola holds the hammer back and says, "I'm going to F you up." That is the real Mr. Arriola. Unfortunately, that's the Mr. Arriola that was out at the ranch that day. That's the Mr. Arriola that attacked Mr. Cummings. Mr. Chavez made a statement when he testified yesterday that really struck me. And I'd submit to you, ladies and gentlemen, to consider this. Mr. Chavez said that Mr. Arriola was only aggressive when he was drunk, or when he was intoxicated. But he was intoxicated every day. That is the Mr. Arriola that attacked Mr. Cummings. Mr. Cummings got on the stand and testified and told you all what happened. He also told 911. He told Mr. McCullough. He told the police when they arrived on scene. And he told you that he acted in self-defense. Can't see this too well, but you will be able to see it when you go to deliberate. This will go back with you. This is the instruction for self-defense. And what I want to point out to you, ladies and gentlemen, is that the burden is on the state to prove by a reasonable doubt that the defendant did not act in self-defense. The burden is on the state. It's not on us. We don't have to prove he acted in self-defense. They have to prove he did not. But ladies and gentlemen, I would submit to you that not only did we prove beyond a reasonable doubt, we proved beyond all possible doubt that he acted in self-defense. Let's talk about what the evidence shows there. Mr. Cummings described for you, when he testified, the relationship that he had with Mr. Arriola. He described that they got along pretty well. They spent a lot of time talking about the ranch. They went horseback riding together. They even spent a night drinking whiskey. Of course, it was the night that the two of them were drinking whiskey that he started to see some red flags with Mr. Arriola, when Mr. Arriola started to share stories about his neighbors. Now we can see why Mr. Cummings would have been a little bit apprehensive about getting crossways with Mr. Arriola after hearing the stories about those neighbors. But Mr. Cummings tried to continue to get along with Mr. Arriola because he wanted to buy that property. He really wanted to get that land, and he wanted to build his home and his guiding company. He had no motive to kill him. Killing Mr. Arriola kills the land deal. So the state cannot present to you any sort of a motive for why he would have killed him. And you don't have to take Mr. Cummings' word on how things happened that day, because the physical evidence actually does show you that he acted in self-defense. First, starting out in the kitchen, the state's trying to direct your attention over to like the living room area and saying there's no sign of a struggle in the living room. Well, of course there's not a struggle in the living room. We all have heard the struggle never happened in the living room. I don't know why they keep trying to direct your attention there. But what we do see are Mr. Arriola's sunglasses laying on the floor right at the location where Mr. Cummings said this all started. Right where he was attacked for the first time, right here, next to this counter. And he's described for you when the very first time Mr. Arriola attacked him, he went down on the floor. He didn't go flying over to the stove. He didn't go across the room to the living room and start tearing that up. No, he went into the hallway. And he described for you how when he went down, his firearm happened to be sitting right about there. His firearm that he was preparing because he was going to go hunting. And when Mr. Arriola attacked him and was over him, he grabbed the firearm away from him. He grabbed it away from the wall in an attempt to defend himself. And he described for you how the fight went down the hall, how he was knocked down again by the bathroom, and he tried to get up, and he did get up, and at that point in time, he held the rifle and pointed it at Mr. Arriola and said, "Stop." He was trying to stop this attack, but Mr. Arriola didn't stop. And the state's arguing that's not what a reasonable person would do. That is correct. That's not what a reasonable person would do. But what we all know now is that Mr. Arriola wasn't always a reasonable person, especially when he was drunk and on cocaine. Far from being reasonable. The fight continued into the bedroom, and we hear about how he was tackled again. Tackled again for a third time in the doorway of that bedroom. And what do we see? What do we see there? The state says there's no physical evidence of any sort of a struggle. What do we got right there? We've got a propane heater knocked off the wall. We see the brace that holds that heater up. Knocked off the wall, laying on its side in the bedroom. What is that if not signs of a physical struggle? And then the struggle continues in the bedroom. And as we've already heard, ample testimony, and we've seen the impact shots. Two shots go off with the gun upside down on the floor, completely indicative of a physical fight over that gun. A struggle for the gun that's going to result in one person living and one person dying. Mr. Cummings did not want to be the one who died. A physical fight where Mr. Cummings is retreating away from Mr. Arriola back into that tiny bedroom. And the state's going to make a big thing about how small that bedroom is. Ladies and gentlemen, I submit to you, that makes it all the more credible that Mr. Cummings would feel in danger for his life. He wasn't in some big room that he could retreat even further, which, by the way, the law in New Mexico is that you do not have to retreat. You can stand your ground. But despite that, he did keep retreating. All the way down the hallway, he kept retreating until he gets to this tiny little room where he can't go any further. He can't go any further. He is trapped in that room with a crazed man attacking him over and over again. And you could see the rug pushed up, bunched up, to where Mr. Cummings couldn't go any further. He had nowhere else to go. The gun is already going off. It's already shooting stuff all over the place. The gun's already been shooting bullets all over the place. As you hear from Mr. Brudenell, it was a chaotic scene. We have at least 3 different angles of gunshots at that scene, indicative of a struggle. And finally, what we have in this photo, you can see where the scope cap was ripped off the rifle and ends up under Mr. Arriola's body. Ripped off under his body. That's critical. That is completely consistent with what Mr. Cummings described as how Mr. Arriola was pulling on that gun, trying to pull it away from him, pulling on the scope. And he's pulling so hard that it doesn't just tear the cap off, but there is electrical tape to make it even more secure. And it breaks the cap. It breaks the cap and lands under the body. And finally, what do we find in Mr. Arriola's hand? A canister of mace. The state is trying to make a big issue out of the fact that Mr. Cummings was describing it as a poison. Maybe he called it a poison. Neurotoxin, chlorophyll. If Mr. Cummings had planted the mace in Mr. Arriola's hand, wouldn't he know what it is? Wouldn't he say there was mace in his hand? Instead, he's describing it all these different ways because he doesn't know what it is. All he knows is that there was something black and hard that he was being attacked with over and over and over again. Because we know now, Mr. Arriola liked to attack people with mace. Now let's talk about Mr. Cummings' behavior after the shooting. Mr. Cummings immediately ran out, washed his face, washed his hands. Still burning. That's consistent with the testimony we've heard that water isn't a good way to treat mace. He didn't know that. So he ran inside and got some soap, came out and continued to wash his face. Took a while for the burning to stop. But once the burning stopped and once he could breathe again, what did he do? Ladies and gentlemen, I would submit to you that every action Mr. Cummings took after this shooting are the actions of an innocent man. We're out in the middle of nowhere. There's nobody around this ranch. If he had actually just murdered Mr. Arriola, why didn't he just leave? No one's there. He could just say, I have no idea what happened. Why did he stick around? Why did he wave down Mr. McCullough? Why did he call 911? Why did he wait hours for the police to arrive? Why did he gather up his clothing and put them on the bed of his pickup truck? Why did he put the gun and the magazine on the front porch steps? Why did he do all of that? He did all of that because he acted in self-defense. The state's making an issue out of the fact that he asked Mr. McCullough to be a witness for him. He explained to you why he wanted a witness. He was scared. They were out there in the middle of nowhere. He had just shot a man. He knew that police were going to arrive because he asked the police to be called, and he called the police himself. He knew that when the police came out there, they were going to be on edge. That's reasonable. He knew they were going to have guns drawn on him. So he wanted a witness not only to what had happened at the ranch, but he wanted somebody there to be a witness to the police. And Mr. McCullough was that. Mr. Cummings did everything he could to assist the police in their investigation. Despite everything he did, the police still didn't do a complete investigation. They gathered the clothes, but they never test them. They take the gun, but they never test it for mace. They never even tested the mace canister. They never even called the mace manufacturer to ask if this had dye in it. The state's asking you to look at this mace canister and decide that it has some kind of dye in it. There's no evidence of that. And in fact, this looks more like rust than any sort of a dye. And the testimony we've heard from the two people that actually were maced by Mr. Arriola is that the mace he used didn't have dye in it. But regardless, the state could have tested these things. The state actually did do a little bit of testing of the firearm. You heard Mr. Brudenell describe for you how they did some basic firearm testing to make sure that it operated. They tested the gun to make sure it worked. How is that helpful? What does that tell you about this case? Nothing. We already know the gun worked. He just said he had used the gun to shoot Mr. Arriola. So that wasn't in dispute. All that shows you is that the state is capable of doing testing. They just chose not to. Ladies and gentlemen, the state has the burden of proving beyond a reasonable doubt that Mr. Cummings did not act in self-defense. All of the evidence in this case, all the physical evidence, everything that you have seen corroborates Mr. Cummings, corroborates the fact that he was attacked. He was attacked not once, not twice, not 3 times. Repeatedly, over and over and over again. He was attacked by Mr. Arriola till the point where he was up against almost a wall. He was up against those beds with this man over him, still coming at him. Still coming at him. And that he scrambled up to his feet, and you see from the way the rug is all bunched up right where all of this happened, he's scrambling to his feet, pulling on the gun, and he even tells you how at one point he decided, Dean, if you don't get serious, you're not going to be a dad anymore. And he then takes his other hand, his left hand that he had been using to block Mr. Arriola's strikes. At that point, he realizes, this is it. This is it. I need to get serious or I'm going to be dead. When that happens, he grabs the gun with his left hand, raises it up, and shoots at Mr. Arriola as he's coming towards him again. The trajectory of those bullets shows that right to left pattern in a downward position that is completely consistent with someone attacking. He was attacking Mr. Cummings at the time he was shot and killed. The state tried to suggest that Mr. Arriola was an old man. He wasn't an old man. He was 47 years old at the time of his death. 47. younger than Mr. Cummings. Ladies and gentlemen, the state's going to make their rebuttal closing, and then the case goes to you. At that point in time, the power is going to shift. The power that the state has and law enforcement had when they conducted their investigation shifts to you. And then you have the power to review their investigation, review their prosecution. And you have the power at that point in time to take the facts, look at the law, and render a verdict. And I would submit to you, ladies and gentlemen, that all of the evidence in this case points to only one verdict, and that is not guilty on both charges. Thank you.